And the contract 9C, the work started. And then the second, the witness mentioned that cost recovery for Sumigita is like this in 2008, amounting $340,000 in FQR Report 8, line 3, column contract service. The total is $23.7, whereby remediation cost is $340,000 is included there. 2009, amounting to $7 million in the actual capital column, amounting to $1.9 in FQR report line 43, column contract service, and discount of payment amounting to $4,300 in the FQR 2009 report 11 line 47 sundries column, and 210 amounting to $2.1 million in the FQR and contract service column, and discount payment amounting to $18,000 in the FQR 2010 the sundries column 2011 amounting to $2.4 million, and report 8 column contract service and discount of payment $18,000 included in FQR 2011 column sundries, and 2012 in the FQR 2012 line 2 column service contract service, discount of payment amounting to $3,000 and report 11. So the evidence, the letter about contract of services, the second one is bridging contract C9 1st of September about a contract for procurement, also so for management of facilitation, and evidence invest contract okay amounting to starting from 5th of December 2012 up to the 30th of December 2001, and invest contract number C 95 two invoices 17th of December 2012 and 27th March 2012. Considering the testimonies of the witnesses and also the evidences, the work of a defendant in the contract with the contract value amounting to $6.285 million, with the implementation period of 3 years from, and the bridging contract number C9516 with the value of the contract $741,000 for the implementation period of 6 months up to 13 May of 2012, and the value of the contract amounting to 6.24 in the addendum 2 from the contract 781. Okay. Added with and so implementation period is extended to 31st of December 2012, and the bridging contract number C911 amounting to $241.0.2 with the implementation period 6 months up to 13th of May 2000 May, and the remediation work is going to be done using the same method, hauling in, hauling out, by transporting the land from the area to COCS, bring it to the processing pit and do the tiling and provision of nutrients for microorganism, and it is taken to the basket and also spread it to the spreading area, and doing piling using total factor and microsensors with the using the hauling out from the processing pit to spreading area that has been determined by CBI. Considering that the element of unlawful action has been proven, that bioremediation has been done by Sumigita based on the contract number C781, and in 2011 SCG did again the bridging contract C951 that was completed in March 2011. Considering that based on the description above, all the elements of the primary allegation have been fulfilled, then beyond reasonable doubt the defendant has been proven to be guilty. That has been conducted corruption in violation of law number 31 about corruption eradication, in conjunction with that has been amended by law number 20 2001 about amendment about law number 31 1991 about eradication of corruption, junto article 55 of the criminal code. Considering because of the primary indictment have been proven, then subsidiary allegations should not be proven, and for other defense, the defense has been accommodated and also included in the consideration of the facts that have been described before. Then the denials of the defense, the secondary evidence and refuting evidence, as the evidence presented by the defendants cannot refute the evidence presented by the prosecutors. And considering that one of our judges has the dissenting opinion by saying that considering in this panel, Sofiadi has a dissenting opinion, and Herland Bin Ompo has been declared to have been guilty in violation of the law number 31 of corruption eradication that has been amended by law number 20, and also in conjunction with the penal code as included in the primary indictment, and based on the judiciary authority, if there is if there is a dissenting opinion, that has to be included in the decision, and the dissenting opinion is based on the following opinions: that the defendant has been alleged by violation of corruption law and is charged with, and also subsidiary corruption as alleged by, and considering that the defendant has been alleged by subsidiarity principle, that's why the judges will prove the primary indictment first, and if it's not proven, then they will consider the subsidiary charges. And considering the primary charges about that is related to the violation of corruption eradication law that has been amended by law number 20, that is about the amendment of law number 31, and also in conjunction with the penal code and the elements of those are this: for every person, violation of law, and enriching yourself and also other people and corporation, and brings state financial loss. And 5, participation as mentioned by our criminal code and continuous manner. And considering that to declare that defendant has been guilty of the indictment, then the judge will look at each of the facts of the court hearings. The first one, for everyone according to law number 31 about corruption and irrigation, this is a natural person or a legal person. So natural person is a subject of law and that with responsibility and rights. And referring to the decision of Supreme Court on the 10th of August 2003, the element is anyone can be meaningful if it is related to other elements, and then subject of law can only be considered if the indictment has been proven. And based on this, defendant Herland Bin Ompo has identified his identity, has included in the indictment when the panel of judges asked him. He was the director of Sumigit Ajaya, and this is the vendor in doing and implementing the soil bioremediation SBF in Assam, Chevron Pacific, Indonesia area. And defendant, when he was presented in the court, he is in a healthy condition. And considering that based on the facts and those considerants, then the element every person has been fulfilled. The second one, violation of law. Considering that law number 31 about corruption eradication that has been amended by law number 20%, a violation of law is in the formal and material construction, and after clarified to reach all the modus operandi related to state financial calculation that is more complicated now, then it now covers the action that can enrich someone and also other people and also corporations in the formal and material understanding. And this can include unlawful act, although it is not regulated by the laws, but if this action is against the norms, the social norms and decency principles, then it can be criminalized. And considering that if we refer to the Constitutional Court decision dated 24th of July 2006 that says that as long as the unlawful action is not violating the our constitution, and this is just a formal understanding in the sense that this is unlawful action if it has been regulated before in the regulation, and it has to be in writing, it has to be clear, and you cannot use analogy or you cannot construe it in a narrow way so that there is a legal uncertainty. And considering because of these considerations and also the facts in the hearing, then the judge member will consider the participation at the procurement tender by Herland because his company was not in the waste treatment. This is in violation of Chapter 1, Point 1, PTK 007/6 that mentions that the requirement for providers of goods and other services, they have to have a business license issued by authority, and this has to be valid. For example, SIUP, business license for trade and also for construction work. There is a certain license for this. And considering the facts in the court that Sumikita Jaya has experience as the subcontractor of Tripatra, and based on the announcement of a tender by CPI, there was no requirement that there should be a license in bioremediation. And considering this, there was no, in the absence of such a requirement, that there should be a special license, and participation of Sumigita, be it from administrative point of view and also from technical point of view, it was not asked or questioned by the procurement committee, and for supply chain it only applies for all the contractors in the supply chain. And from the PTK regulation that is released by BP Migas, it doesn't bind subcontractors of the contractors, so Sumigita Jaya doesn't have to comply with this regulation. It's different if the project is financed by state budget, then it has to comply with the regulation about public procurement. And in consideration to that, Sumigita Jaya should not be obliged to comply with PTK 007, because Sumigita Jaya is not a contractor, and this PTK is released or issued by BP Migas to be binding on the contractors in the mining operations contractors. And this actually already opens an opportunity for domestic corporations to be and they support the documents, and the following documents. The first one is the deeds of incorporation, and then the copy of tax paying reference, and the last balance sheet. And considering that based on those considerations, the member of judge was in the opinion that Sumigita Jaya was not doing an violation of law if it is done by the member of procurement committees who were not certified to do contract 781. This was not in violation of C 18 PTK 007/6/2004, and that says that a repeat order for procurement of goods is not allowing the results from the previous committee. Considering that there is a mistake that is used as an argument of prosecutor, according to the judge, the prosecutor has misinterpreted the meaning of PTK 007. Actually, to signify this, you have to read the failure of bidding process, which is declared if the number of bidders that are eligible is less than 3. So look at PTK 007/6/2004 16 point, and for rebid. Considering that in the process of procurement, it was never declared that the procurement was failed, and the replacement of the procurement committee that were not certified had been approved by BP Migas, about the replacement of the procurement committee for the contract 781. Okay, considering that with the replacement of this procurement committee by Chevron Pacific Indonesia, which was already approved by BP Migas, according to judge, there is no violation done by Herland Bin Ompo that leads to the nullification of this contract. And the prosecutor also blamed Sumikita in the bridging contract, that they don't have the laboratory and also the equipment. And considering this, the opinion of Judge 4 is like this: based on the as they charge testimony before the court, according to PTK 007 2011, it shows that direct appointment was allowed in order to maintain the sustainability of the work that is ongoing. And direct appointment was allowed as long as it does not exceed the period of 6 months. And considering, based on the testimony of the other church witnesses, that was complementary and was strengthened with the provisions of PTK 007, 2011, 19 January of 11, page 128. It is proven that bridging contract Herland Bin Ompo with CPI is not in violation with the provision from BP Migas. Considering that the judge 4 will reconsider the prosecutor's argument that Sumigita did not have the license or doesn't have the license as set forth by the ministerial decree that sets forth that a producer of waste, in this case CPI, then the license has to be obtained by Chevron Pacific Indonesia. Well, Sumigita, as a subcontractor of the contractor that did bioremediation, will be considered like this. According to Article 2, Ministerial Decree of Minister of Environment, all operations that will lead to waste, produce waste, has to treat the waste, and it can be bioremediation technique can be used, and that includes land farming and other methods, and to treat the hazardous and toxic waste according to the ministerial decree. For each of the legal entity or business entity, they have to have a license from the head of the institution. And the second one, the provisions about the procedures as meant by 1A has to be determined by the authority, and related to COCS, it can be bio-treated as an alternative of the technology to treat the waste. And this is the authority of KLH, and there is this regulation from KLH about the procedures to treat COCS using biological method, and the format to apply for the license for treating COCS using biological technology. And in the court, there have been testimony from the KLH, and that is the testimony from Dr. Anda Masnelati and the witness Wiryono Kusmo Sudiarjo, who have explained as follows. Chevron Indonesia, as the producer of waste, has to conduct treatment of the waste according to the regulation 2009 about the protection and of environment, in conjunction with the ministerial decree 2009 about the procedures to rehabilitate and recover the land from toxic waste. An institution that is authorized to give licenses KLH, and based on those facts, the license for PTK and also to treat COCS, this is given to the producer of waste, in this case Chevron Pacific Indonesia, and there is no obligation for the contractor that works for a contractor that has the license from the KLH, and that was already strengthened by the testimony and also strengthened by contract, and it has proven that Sumigita Jaya Herland Bin Ompo is not obliged to obtain the license to do bioremediation work in SBF. So this is not in violation of law, not in the violation of the provision of Ministerial Decree number 128. And considering that Judge 4 will consider whether the COCS treatment done by Sumigita is using remediation as set forth by the Ministerial Decree number 128, according to procedures that are regulated by the second annex of this decree, and also based on the principles of BI remediation as already explained by Edison Effendi MT, which is in principle saying that just by plowing the land and also giving the nutrition, this is not bioremediation work, because in the world bioremediation you have to use microorganism, and you have to conduct treatability study to check the bacteria in the soil, because not all the bacteria can degrade the toxic in the land, and after that you have to do isolation to be able to know the characteristics of the bacteria. So you have to do isolation of that bacteria, and if you have already know the amount and the type, and after that you can determine the concentration of the nutrients so that the growth can be good. And usually the nutrient used is nitrogen, and adding has to be very carefully done because it will give impact to the nutrients, and the formulation is usually 100:5:1. This is the ratio of C and P, and this is only used for liquid waste, and this cannot be used for all contaminated land or soil. Considering that considering the testimony from Edison Effendi, Judge Member 4 will consider whether Sumikita has already violated the Ministerial Decree number 128, and in doing this work, Sumikita only did the mixing of the soil without doing the characteristic site as mentioned in the indictment of the prosecutors. And considering that toward the site characteristic testing to the land within the operation area of SLS, a long study has been done by Herland Pacific Indonesia, that used to be called as Caltex Pacific Indonesia, from the laboratory testing 1997, and also site testing, and also after the until the issuance of license. And the fact is that the treatment for COCS was very practical and economic, because it can be used, the microorganism from that land can be used there, and with the determination of the bioremediation, it has been relied on the studies and also the expert of bioremediation, and it was decided by KLH through the Ministerial Decree 128 for the procedures of doing bio treatment, and the responsible party for doing this bio treatment or bioremediation is for the or on the producer of waste, and that is to use bioremediation technology, analysis of the treatment procedure and criteria of the result, and also handling and supervision of the result of the treatment. And point A up to F has been fulfilled by Herland Pacific Indonesia when a license was applied, and before the expiry of the license, and license was applied from KLH. And related to this is not obligation of Sumikita or the obligation of Herland Bin Ompo. And considering that for bioremediation, this is under the responsibility of KLH, how the procedure should be done, how the ministerial decree has to be done, and this is not for the expert Edison to decide. And Edison Effendi, as an expert, was presented here, and Prayitno participated at the tender in 2007 at CPI, and he also was acting on behalf of Trio Putra, and also was participating at pre-qualification in the bidding process at CPI. And this fact was supported by the evidence, and that was the document supporting this fact. He was acting on behalf of the NLMI, the director of Ria Putrai, to get the documents and also to participate at the clarification meeting and other things. And to consider that, according to Judge Member 4, the expert was involved in conflict of interest, and consider that in the court another fact was also found, that the sampling was done by FND in one of the lab in the AGO, and the analysis, such analysis was in violation with the ministerial decree about the laboratory for environment. In the first article, the laboratory has to be accredited as testing an environment lab, and the lab has to be registered. And to get this recognition, the lab has to have the accreditation certification as a testing lab with then it has to be issued by a prominent certifying institution, and the lab has to comply with ISO 1702, the most updated edition about the testing and calibration lab, and complying with the regulation that is that constituted an inseparable part of this decree. And considering those, the lab that has been used for sampling testing and presented by prosecutors, this is not valid and cannot be scientifically proven, and also to especially for doing the arguments. And based on those arguments, the judge, Judge Member 4, concluded that unlawful action that was alleged was not proven, and therefore Herland has to be released from the primary indictment. And because this is not proven, then subsidiary allegation or indictment has to be looked into, and this is related to the violation of the law of corruption. The elements, the first one is any person, the second one to enrich oneself, corporation, and to misuse the office or the power, and to lead to state financial loss. And he is participating and seeks continuous action for element every person. So for this for any person, this is it has to be an inseparable part. So any person element has been fulfilled in this case. The second one, to enrich one person or other people or one corporation. Considering that this element is a subjective element, and according to Article 3, this is the objective of the person when doing a misuse of authority or power, that in doing his work as the director of Sumikita Jaya, in fulfilling the contract to do bioremediation up to February 2012, and in winning the contract of bioremediation in SBF CPI in 8D location, A 8D 72SS minus, 8D 5 SLS minus, C 5C 99 SLS minus, D 4C 47 SLS, GS SLS minus, and location Kota Bata. considering that in the court other facts have been revealed, the contract has been completed by Sumigita, and CPI as the employer also has accepted all the operational maintenance, and it has been according to the period of the contracts. And considering that the problems that are used as the basis of this case by prosecutors is that the allegation that the contracts were not done by Sumigita because the results were null, by referring to the expert opinion by FND, and it was we know that he was involved in a conflict of interest because he offered and participated at the tender process and was acting in the name of Trio Putra's director, and he was attending in the clarification meeting for the remediation work, as was and considering those facts, the judge member 4, the profit that is received by Herland Bin Ompo is according to law and is not in violation of his power, and because of the profit that he gets is as the payment for the services from the employer, and this is a natural profit and in line with the performance that he already did. So the element to enrich himself or other people is not fulfilled, and because the two elements are not fulfilled, then other elements should not be considered anymore. So he has to be released from the subsidiary allegation, and because the primary and subsidiary allegation or indictment are not proven, then Herland Bin Ompo has to be released from all the indictments, and as a consequence he has to be exonerated, and this is the dissenting opinion from judge member 4. So this is approaching the prayers time, so we're going to have a break 15 minutes and we will adjourn after that. Thank you.